Hello, everyone. We'll be starting in a couple of minutes, about 2 minutes past the hour to give people time to join us. We'll be starting in about 2 minutes to give folks time to join us. All right, everyone. It's been it's been a couple of minutes past the top of the hour, so hopefully everyone's here who was intending to be here. Welcome. Let's talk about debiasing the law. Now, before we do that, just so that you know the logistics of the matter, I will be having my slides right next to me and below me. So if you are unable to fully see the slides, if they're cut off in any way, what you'll want to do is go to the button View at the top right of your screen and change it to full view speaker. So it should be set on speaker so that you can see the speaker and the slides clearly, and it should be set to full view. This is much more engaging. This is called a virtual camera, and it's much more engaging than the typical PowerPoint presentation, which is why I did it. All right. So without further ado, let's launch into the presentation. The first thing I want to talk about is how decision-making happens. This whole conversation will be about decision-making and biases. So we're talking about biases. What does that mean? Bias means something, debiasing the law, is about addressing flaws in our decision-making. So that is the essence of the presentation. How do you address flaws in decision? It doesn't have to do, it can include bias toward other people in terms of ethnicity, race, religion, and so on, those stereotypes. But it's much more broad than that. We have all sorts of biases in how we make decisions around people, and how we make decisions about projects, and how we make decisions around the law, anything. So you as defense lawyers need to know that and understand that. And the first thing I'll talk about is a bias called the framing effect. Framing effect. So think about, from a framing effect perspective, ice cream. Let's think about some ice cream. Let's say you open your fridge and you see you have two containers of ice cream in the freezer. One that contains 10% fat, one that's 90% fat-free. So 10% fat versus 90% fat-free. Now think for a couple of seconds, which of those sounds more appealing to you? Do you want to have the fat-free ice cream, or do you want to have that's 90% fat-free, or do you want to have the one that's 10% fat? So think about that for a couple of seconds. Which of these is more appealing to you? Okay, now that you thought about this, let's have a little poll on this. So please go ahead and put in the poll. You should be able to see the poll on your screen, whether you prefer the fat-free, that 90% fat-free, or the one that's 10% fat. Which one is more appealing? All right, so you should be able to see the results of the poll on the screen. We have over 7/10 of you prefer 90% fat-free. Under 30% prefer 10% fat, and everyone has a preference. Now, let's think about this logically. 10% fat, by definition, means 90% fat-free. 90% fat-free, by definition, means 10% fat, right? That's what it means. That is the math. You can all do the math on this. It's easy enough. And so what's going on? We shouldn't have a preference, right? Logically, they're the same thing. We should not prefer one to the other. But clearly, there is a strong preference for the fat-free ice cream. And the thing is, how we see and interpret the world is determined by our frames, how we frame things to us. So think about how various framings of legal cases can shape your perspective. Can shape your perspective, can shape the perspective of the trier of the case, the jury, the judge, can shape the perspective of all stakeholders involved in the case. So this is a really important issue from your perspective as a defense lawyer. How are you framing the case? Different framings can have very different outcomes. So are you thinking correctly and clearly about how to frame the case effectively? What about the prosecution? How are they framing the case? So this framing, as we see from this example, I mean, you're all defense lawyers, you kind of understand probably intuitively the idea of framing. But here we see that everyone is vulnerable to it, including defense lawyers, to the framing effect. So you need to understand that this is something that really is a powerful force within us, and that causes us to make some erroneous decisions based on how a legal case is framed. Now, at this point, I'll want to give you a little example of an interesting framing. So you might remember the O.J. Simpson's case. Maybe that ages me, but it's definitely something I recall from my younger years. And here is a particularly salient moment in the O.J. Simpson murder trial case. So let's take a look at this. Make sure that you have your sound on. Of course, you should have your sound on because you're listening to me, but you should be able to hear the sound when I play.
O.J. Simpson in a knit cap from 2 blocks away is still O.J. Simpson. It's no disguise. It's no disguise. It makes no sense. It doesn't fit. If it doesn't fit, you must acquit.
I'll be back.
Okay, all right.
Okay, so hopefully that was illuminating as another example of how this issue is framed, but also another cognitive bias that we'll talk about next. So thinking about framing, that was framed that, hey, it's not the skies. What John Cochran said, it's not the skies. So he's framing it to the jury. He's has the knit cap on, right? Kind of visual illustration. That was one example of framing, how this is framed to the jury. So thinking from a defense lawyer perspective. But another example here is the end of what he says. If it doesn't fit, you must acquit. If it doesn't fit, you must acquit. This is called the rhyme as reason effect. If something rhymes, then it is more convincing. This is about cognitive fluency. So thinking about phrases that have cognitive fluency, what does that mean? It means they're easier to understand. So phrases that are easier to understand are something that we tend to believe. And something that rhymes is something that we tend to believe, something that is a metaphor or an allegory. Those are things that make it easier to accept information as truthful, as believable, because it's easier to process for our brains. It's better fitting. So this is called the rhyme as reason effect. This is more believable. It creates trust. And so your role as defense witnesses, of course, defense lawyers, is to create trust in your clients and in yourself. And using rhythms, rhyme as reasons, using metaphors, using allegories, things that people would relate to easily and they would accept. So they need to accept the subcomponents of your case, and if you frame them as rhymes, they will be easier to accept. So this is the rhyme as reason effect, and something for you to seriously think about as you are proceeding in your cases. What's going on here? Why does the framing effect impact us? Why does the rhyme as reason effect impact us? What's going on here? Well, the thing is that our decision making is fundamentally emotional. No matter how reasonable and logical your case is, if the jury is not moved emotionally to trust you, to believe in you, to accept your version of the case, they will not rule in your defendant's favor. And so we really underestimate the role of emotions in our decisions, in courts and so on, in all sorts of areas, legal areas, not legal areas. Recent studies show that emotions drive 80 to 90% of our decisions. So we're overwhelmingly driven by our emotions, no matter how much it might feel to us that we're driven by our logic. When we do what comes naturally to us without using evidence-based decision-making strategies, we are overwhelmingly driven by our emotions. And the vast majority of people, unfortunately, are not really cognizant of this, and they don't use evidence-based decision-making strategies to address these emotions. And you as lawyers, defense lawyers, need to understand this in service of your clients. So let's talk about the specific forms of bias. There's explicit bias, where people are explicitly knowingly prejudiced and have preconceived prejudiced opinions against certain people for some reason or other, or certain situations. These are explicit bias, and that's certainly something that you need to be watching out for, but you probably already watch out for that to some extent. hopefully you are doing this pretty seriously. The problem is the implicit bias. Framing effect, rhyme as reason effect, that is not explicit bias. That is not a preconception against anyone or any situation or any institution. Implicit bias is a form of failing to protect yourself from bias that leads to poor decisions, failing to protect your clients from poor decisions, failing to protect the legal system from poor decisions. So this is a big, big problem. This is what I want this is what this presentation is really focusing on. The implicit bias, the things that we don't understand are happening and that we just fall prey to because we don't understand and we don't know that they're happening. It's crucial for many, many fields of law. So not only for defense law, but many fields of law: employment law, public procurement, jury selection, criminal defense, which jury selection and criminal defense are definitely relevant to you, business decision-making, bankruptcy, police misconduct, relevant to you, and many other areas. So you want to really be aware of what's going on in any specific situation and how it might impact your case. And there's lots of areas where it might impact your case. So let's talk about some specific concrete examples that I want to get at. Let's share my screen. All right. So I often serve as an expert witness, and this is kind of the perspective I come from. So I often serve as an expert witness on bias. And so here is an example of one case that I want to share with you about. It's an expert witness report, as you see, prepared by me. Let's see. So brief overview, just so you know what's going on. So an African-American man, Amaria, was shot and killed by Kansas City Police Department officer Austin Schuler during a traffic stop, where he initiated a stop without expressing clear justification. Mr. Henderson became agitated. He, in a state of severe anxiety and panic, he attempted to drive away. The officer reacted by literally jumping into the vehicle and firing 2 shots. And the lawsuit is about civil rights, excessive force, wrongful death, and negligent infliction of emotional distress. So this was brought by the family of the deceased, Mr. Henderson. And so the officer was behaved in a very problematic way by jumping into the car, into a moving vehicle and shooting into it, which is very much against police use of force standards. Okay, so here is stuff where I'm analyzing him. Oh, this is not so relevant for bias. Here, I want to analyze the actions of the police, Officer Schuler. So he pursued a course of conduct that represented a deviation from standard protocols, escalated the encounter. He, despite being prepared for such tense, stressful, and violent situations. Let's go through this. And here I talk about some cognitive biases that are going to be relevant later, which I'll mention briefly in the presentation as well. But this is the Horn's effect. Is a cognitive bias in which a single negative characteristic leads individuals to negatively judge other unrelated attributes. Anchoring bias, and again, you see this is not like necessarily about a preconception. This is about implicit bias. Anchoring, where you tend to rely excessively on initial information when making judgments. Confirmation bias, we tend to search for, interpret, and recall information in a way that confirms our pre-existing beliefs and expectations. And the empathy gap. Individuals underestimate others' emotional state, stress, and anxiety, especially those with whom they don't feel a sense of connection. Okay, so Mr. Henderson, of course, shouldn't have driven away. That was not great, but there was a number of issues which related to it, and he wasn't prepared and trained. Whereas Officer Schuler, of course, had extensive training, and we should expect calm and rational response under duress, under stress of all sorts. And he wasn't in a state of danger when he jumped into the moving vehicle. So he made the decision to jump into a moving vehicle, and at that stage, he was in a state of danger, but of course, he placed himself in that situation. And here I talk about how the president of the International Association of the Chiefs of Police said that the only times that when it's justifiable is when a vehicle itself is being used as deliberate means to kill others, or a person in the vehicle is threatening the officer or another person with deadly force by means other than the vehicle. Once he wasn't threatened by the vehicle, he was on the side of the vehicle, which is why he was able to jump into the door, which was open. So here is an analysis that you can think about applying to your own situations when you are trying to defend your clients. So, Horn's effect. How are you presenting this information to the jury? Officer Schuler appeared to fixate on a negative attribute, likely his race, his size, his perceived noncompliance, allegation of burnt marijuana. But given the previous history of the Kansas City, Kansas Police Department, race is likely an issue. Officer Schuler allowed whatever he perceived to cast an overwhelmingly negative light, and given KPCD's history, race appears as a very likely category. So that's Horton's effect. Anchoring bias. His initial hostile perception of Mr. Henderson anchored all subsequent judgments, even when Mr. Henderson was unarmed, anxious, and verbally pleading. Once he classified Mr. Henderson's actions as deliberate resistance, Officer Schuler selectively interpreted any behavior to confirm wrongdoing. An empathy gap. Lacking any direct personal trauma akin to Mr. Henderson's, he wasn't able to empathize with him. He underestimated the effect of fear, confusion, and medical vulnerability. And he was oblivious to his feelings of anxiety and trauma, and he failed to engage with de-escalation tactics specifically designed to address civilian panic and high-stress encounters. And then I kind of go on a little bit more about how it also relates to the KPCD's department entrenched failings, that they didn't give him training on this. They didn't address how bias can corrupt and harm policing. So that's an example of applying and communicating about cognitive bias. Of course, I did so during the deposition and so on. But this is in a written document, which I can share with you easily in a way that I can't share deposition testimony or something like that. Okay, let's go on to talking about the nature of decision making. Going with your gut. A lot of people, jurors and so on, trust their gut. Gurus like Tony Robbins tell us to go with our gut, go be primal, be savage, trust our intuitions, follow our heart. And that feels very comfortable, but it often leads to disastrous decisions. It feels good, but it does not result in good outcomes because our gut is not evolved for the modern environment. It's actually evolved for the ancient savannah environment, not the modern world. And we need to understand this, that our gut intuitions will lead us astray very often. Tribalism is an especially big problem. We lived in small tribes of 50 people to 150 people in the ancient savannah. And that's what we evolved to live for and to be with, small tribes of people. We're not evolved for a complex multipolar world with people of different races, ethnicities, religious backgrounds. And so we make mistakes and we lack empathy and we feel confirmation bias and Horn's effect and so on. All of these problems that Officer Schuler exhibited, we feel that toward people who are significantly different from us. In that ancient savannah, it was very important to be loyal to your own tribe. If you weren't sufficiently loyal, your tribe might kick you out and you would die. And it was important to be hostile to other tribes. Otherwise, another tribe would take yours over and you would die as well. And we are the descendants of those who didn't die, who are loyal to our own tribe and who are hostile to other tribes. Another element is the fight or flight response to threats. It was life-saving for hunter-gatherers to make immediate, in-the-moment decisions. But the risks, because the risks they faced were immediate, intense, in the moment, like saber-tooth tigers. That's much more dangerous in today's world. The risks we face are much more long-term, uncertain. They might come from a notification on our smartphone about a disease in the middle of nowhere, China, right? Something like that. And so people like Officer Schuler are specifically trained to resist the fight or flight response to threats. And when they fall into this fight or flight response to threats, that's a very big problem. Whereas people like Mr. Henderson, ordinary civilians, are not trained to resist this fight or flight response. So it's much more understandable when they fall into this pattern. And so you, as defense lawyers, need to think about this when you're defending your clients, that they are much more likely, because they haven't been trained, to fall into this fight or flight response to threats. And police, if they're trained, when you're thinking about police misconduct or anything like that, they are supposed to be trained to avoid the fight or flight response. They are trained in de-escalation tactics, and of course, sometimes they don't follow it, and they need to be rough on the knuckles when they are not following the training. And this all leads to a series of dangerous judgment errors called cognitive biases. So I talked about cognitive biases already. They come from our evolutionary background and how our brains are wired. So I talked about the evolutionary background, the fight or flight response, tribalism, a number of other things. And our brain, and the second thirdly is the wiring of our brain. Our brain is wired to be lazy, to consume as little energy as possible. That's why you have things like the framing effect, where an issue is framed and made easy to us, and we don't have to think hard about it. And so our brain doesn't think hard about issues that are framed in a way that makes it easy for us to understand. Or the rhyme as reason effect, where the information is framed to us in a way that is easy for us to accept. And rhyme as reason, using rhymes, metaphors, allegories, those sorts of things, similes, other tools that create cognitive fluency. Cognitive fluency means it's easy and lazy for us to understand and accept something. So this is something that you really need to understand, how our brains cause us to fall into these forms of implicit bias. Okay, good. Let's go on to another example. And here I want to share with you something that a number of you might have wondered as I started speaking. Not something that, not when you immediately saw me, I look like a normal white mainstream American male, but obviously I have an accent. And a number of people want to know where I'm from, and I'll be happy to tell you. My father is from Ukraine, which is unfortunately well known by now. My mother is from country just to the south of Ukraine, south and southwest, called Moldova. Fortunately, it's protected by Ukraine from Russia. Otherwise, Moldova would have been swallowed as well. So neither here nor there, but that's definitely an issue. And so my parents met, married back when this part of the world was dominated by Russia. And in 1991, I was 10 years old. They left that part of the world when it was freed from Russian domination. They went to the United States, and that's where I grew up, especially in particular in New York City. So New York City is home for me. And if you know New York City, you know it's a very diverse place. You walk a block, you hear a dozen different accents. If I live right now in Columbus, Ohio, go Bucks. But if my parents moved to Columbus, Ohio, which is much less diverse, I probably would have tried to get rid of my accent. but they didn't. And so I didn't try to get rid of my accent because I heard so many different accents around me, and my parents taught me to be proud of my cultural heritage. Now, later, when I left New York City, went to get a PhD in UNC Chapel Hill, everyone, lots of people started asking me, where are you from? And I realized as I was getting my PhD and learning about psychology that there's a tendency that applies to places that aren't quite as culturally diverse as New York City to have negative perceptions of people who have a foreign accent called accent discrimination. So there's a tendency to have a false perception of these people as being less trustworthy. If you're a foreigner, you have a foreign accent, you're wrong, you're weird, you're not trustworthy. It's a false perception, but it is something that is clearly there for many, many people. And it undermines their ability to trust what I'm saying and what other foreigners say. This relates to the halo effect and the horns effect. So a little bit more formal structure of the horns effect that I mentioned about before. The horns effect. It's kind of like how someone has little horns in their head. If you dislike one characteristic of someone, you tend to have too negative view of their other characteristics, it's something that is salient, whether it's accent, the color of their skin, their appearance in other ways, their religion, their ethnicity, politics, whatnot. The halo effect is the opposite. It's like someone has a little halo on their head. If you like one characteristic of someone, you'll tend to have too positive view of their other characteristics. And the negative implications for legal cases should hopefully be obvious. Now, I'll show another video at this stage. The context here is that this is a presentation for RACO, which is the Central Ohio HR Association. This is a closing keynote that I'm giving in 2018. And so I'm a professor at Ohio State, still at that time. And if you know anything about Central Ohio, Columbus, you know it's the home of the Ohio State Buckeyes. We won the championship last year, which is great, college football championship. Our big rival is the University of Michigan Wolverines. Unfortunately, they beat us last year. Hopefully, we'll beat them this year. And so here, there's over 100 people in the room from large companies like Nationwide and so on, HR leaders who are here for the Diversity Inclusion Conference for Central Ohio. This is the closing keynote. So I'm going to ask them whether they will hire a University of Michigan fan. Let's see what they say.
So, as you know, I'm a professor at Ohio State. I'm contractually obligated to root for the Buckeyes. I'm guessing there are a lot of Buckeyes fans here, you know. Go Bucks, right? Yo, there you go. Now, how likely are you to hire a Michigan fan? See, 3 people. Now, regardless of how we feel about Michigan fans and their poor choices in which team to root for, does that indicate anything about their performance as an employee? No, I know. Come on, that no should be stronger.
Hopefully that was also illuminating. So as you see, this is HR leaders that are specifically trained to address bias like this, right? And they're coming to a place, to a diversity inclusion conference. So they're trying to further improve their ability to understand how to address biases. And there's over 100 people in the room, and only 3 people with higher University of Michigan fan. And it wasn't just their initial response, right? It wasn't just a fight or flight, their initial intuition. I gave them a chance to change their mind. And you saw that they weren't really willing to change their minds. The halo effect and the horns effect are incredibly powerful. You need to know how to use these on behalf of your clients and how to address them when you think it might be harmful for your clients, when your clients might be damaged by this. So think about the halo effect and the horns effect and how they might play a role in your legal cases. And be quite aware of this and take steps to address it. Anchoring bias. So anchoring bias is something I briefly mentioned before when I was showing the expert witness report. It's when an initial piece of evidence is much more impactful than subsequent evidence because all evidence is interpreted through the initial piece of evidence. The subsequent evidence is interpreted through this initial lens. And so think about the lens and the first impression that you give. What is the first piece of evidence that you will provide? How will you start your courtroom presentation? How will you start any engagement with the jury? How will you start any conversation where you want to convince the other side? The anchoring is really powerful. And so you need to really think hard about what you will use as your anchor, what you will use as the initial piece of evidence for which you want everything else to be interpreted. The initial statement, the initial framing. So think about the anchoring bias and think about how you can use it on behalf of your clients. Confirmation bias, so following the anchoring bias, but closely related to it, is an instinct to see through rose-colored glasses particular to us. So we turn to look for information that confirms our pre-existing beliefs and reject information that challenges those beliefs. Now, that relates to the anchoring bias, but it's quite distinctive. It's independent of the first piece of information, that you give in a trial. It's the pre-existing beliefs of the triers of the case, usually the jury, obviously, but of course, judges very important as well. So what are their pre-existing beliefs? And how will that impact their perceptions? You need to really understand that this confirmation bias can be highly impactful for legal cases, and you need to try hard to figure out what are the initial beliefs of the jury, what are the initial beliefs of the judges, of the judge in the case, any trier of fact that you will be presenting your information to, any stakeholder, in fact. I mean, you might be communicating to the prosecutor to secure a deal, right, for your client. So thinking about that is also important. What are their beliefs and how will they be functioning to look for information that confirms their beliefs and reject information that challenges them? All right. Let's talk a little bit about attention. All right. So in this video, your goal will be to count the number of times the players in white pass the ball.
The monkey business illusion. Count how many times the players wearing white pass the ball. The correct answer is 16 passes. Did you spot the gorilla? For people who haven't seen or heard about a video like this before, about half missed the gorilla. If you knew about the gorilla, you probably saw it. But did you notice the curtain changing color or the player on the black team leaving the game? Let's rewind and watch it again. Here comes the gorilla, and there goes a player, and the curtain is changing from red to gold. When you're looking for a gorilla, you often miss other unexpected events. And that's the monkey business illusion.
Okay, so hopefully it was also illuminating. It's about attention. Where is the attention of the jury, of the judge, of eyewitnesses going? This relates to cognitive bias called the attentional bias, where we tend to pay attention to what is most emotionally salient, what we feel the most emotions about. Now, some of us who are more conscientious and focused, we might completely miss the gorilla because we're focusing on counting the passes. And a bunch of people who I show this to, they miss the gorilla. But other people, you might see the gorilla, but you might miss other important elements of the situation. And so regardless of whether it's the most important thing, we focus on what is most emotionally salient to us. And a gorilla, of course, can be quite salient, although some people will still not be distracted from their focus. And then when I first saw this video, I tend to be quite conscientious and I was focused. I didn't see the gorilla, and as an example. And people who are tend to be less focused, they see the gorilla, but they very often miss other elements like the player leaving the game or the curtain changing color, which are very important. So the jury might miss quite important things. The judge might miss quite important things. Eyewitnesses might miss quite important things. Your client might miss important things. So this is about missing important information. We need to be aware that attentional bias can be a serious threat to our quality decision making. How do you deal with these biases? What do you do? How do you solve these problems? You need a thorough understanding of these biases. That's the first step. It's good that you're attending this presentation because you're learning about some of these biases, both the specific biases themselves and the mental framework. But we talked about the lazy brain, right? The cognitive fluency, our search for cognitive fluency. We talked about the evolutionary heritage. All of those things, that's the underlying mental framework, the going with our gut, the cognitive biases, the what's going on. So you need to understand that framework of what leads us to make bad decisions, and you need to understand the specific biases themselves to address them effectively. If you're representing the plaintiff, so this is not relevant for you, of course, but I want to give you the perspective of what a lawyer would be doing if they know about this stuff and representing the prosecution here. Look for biases that might cause a defendant to make bad decisions. That's what I mean. I work with both prosecutors and defense lawyers. So when I talk to prosecutors, this is what I advise them to do. Look for biases that cause a defendant to make a bad decision that harmed your client. Demonstrate the defendant did not take steps to learn about biases and protect from biases. Support your case of defendants being liable and protect your clients from claims of biases. Look for and protect potential areas of vulnerability in plaintiff's claims, so prosecutors' claims. So that's what I advise prosecutors to do. What about defendants, it's lawyers like you? Look for biases in the actions of your client so that you can anticipate and address claims of bad decisions. Your clients are definitely going to sometimes fall into these biases. You want to anticipate and address this in advance. And try to demonstrate how your defendant took steps to address these biases. Reduce the likelihood of your client being held liable. Look for biases in the claims of the prosecutors and show how the prosecutor is making bad decisions. All right, I hope that was illuminating for you. For additional resources, go to tinyurl.com/GAE event. Now, you don't have to do this if you're currently on the call, on the video conference, because I will send you the resources anyway, but this is relevant for those who are watching this as a recording. So go to tinyurl.com/GAE event, tinyurl.com/GAE event. And I'll be happy to have a coaching session on helping you address these biases on behalf of your clients. I'll send you a copy of my books. So digital copies of Never Go With Your Gut, How Pioneering Leaders Make the Best Decisions and Avoid Business Disasters, and The Blind Spots Between Us, How to Overcome Unconscious Cognitive Bias and Build Better Relationships. And those will be quite useful for you as you're thinking about how to address biases and learning about them, because you need to learn about the specific biases and the mental frameworks behind it. All right, everyone. So this is everything I want to share at this presentation, and I'll be happy to take any questions at this stage, which you can put into the chat, or we have a small enough group that you can unmute yourself and ask questions that way as well. Don't see any questions coming through. I'll give 5 more seconds for those who have a question to ask. Thank you, Diane. I appreciate it. I'm glad that the presentation was helpful. Good. Excellent. All right. Doesn't seem like anyone has any questions at this stage. So again, I will send you the resources if you're on the call, or go to that link, tinyurl.com/DAE event if you're watching this as a recording. And I hope you have a good rest of your day.